Good afternoon, everyone. My name is Dee Ryan, and on behalf of the team at Limerick Chamber, I'd like to warmly welcome you to today's session. Today is the follow-on from a number of webinars we've been doing in this space, which have been designed to support you, our Chamber of Business community, through what has been unusual operating environment and can be quite a stressful operating environment for many of our members. So I'd like to sincerely thank you for joining us today, and I hope that you will find the answers to some of your common queries in this session on the legal implications of changes that have been introduced as a result of the global pandemic. Today, we are partnering with Holmes O'Malley Sexton, and I'd like to thank Shane Costello, Michael Murphy, Caitlin Love, Sandra Egan, and Robert Kennedy for the time and effort that they've put into preparing today's session. I know you've each put in a number of hours on it, so thank you very much and sincerely for your efforts here. And I'd also like to thank Maria Gleeson, who has assisted in planning the session with us today. There's quite a number of speakers and there's huge interest in the topic. We've received a number of questions in advance, and I know that each of the speakers, each of the panelists have also been consulting with their own clients on a number of common queries. So we've a lot to get through, and without further ado, I'm going to hand you over to Robert Kennedy to kick off. Thanks, Robert.
Thanks, Dee. It's actually Michael Murphy will start.
Thanks very much to everyone, and appreciate the opportunity and the interest in it. My name is Michael Murphy. I'm a partner in the commercial litigation unit of Holmes O'Malley Sexton Solicitors, specialising in insurance law. And the topic I'm going to be talking to you on today is one that's increasingly contentious, COVID-19 business interruption claims. And I think this is both timely and important because it's emerging as probably one of the key issues for both businesses and insurers right now. We are in the midst of an unprecedented crisis that, despite enormous government fiscal supports, has already seen catastrophic effect upon Irish businesses, most of which have been closed in terms of their physical premises anyway, and the orders of the government. For the majority of businesses globally, there's really an emerging cash crisis. Financial Times reported yesterday that half of UK SMEs estimated that they'd be running out of cash in 12 weeks' time. And that means that companies really need to know where they stand very, very quickly indeed, in a variety of ways, but in particular on what their entitlements are for business interruption. These claims are being advanced on the basis of really a type of peril that companies probably never envisaged requiring when they were renewing their policy of insurance. And yet it's now at a point where the survival of those businesses may indeed hinge on the outcome of those claims. It's also a key issue for insurers at the moment, who have warned that this pandemic is likely to be the most expensive event in history for the insurance sector, with the costs estimated to run into the tens, if not hundreds of billions. The Association of British Insurers has estimated that its members' COVID-19 losses will amount to £900 million, and that is for undisputed business interruption claims. The cost of dealing with disputed claims, if accepted, could in fact be astronomical. The American Property Casualty Insurance Association has suggested that covering claims for businesses with 100 or fewer employees in America could cost $5.2 trillion per year. So from your perspective, I think the question you're likely to be asking is, are you entitled to claim for business interruption losses? And there's the short answer and the longer answer. And in short, if you have a policy that includes business interruption cover, then you may be entitled to pursue a claim for losses. And what you're entitled to pursue for might be loss of gross profit or revenue, or additional expenses that you've incurred, such as loss of rent, cost of alternative premises, increased cost of working, so long as they arise from defined perils in your policy. It's estimated that there's about 75,000 businesses in Ireland that have an insurance policy containing some form of business interruption cover. But the longer answer is really that the devil's in the detail. And the question being, will insurers accept that claim, and how will they reach that determination? So that's what we're going to try and tease out today and give you some practical answers. In terms of how insurers reach their determination, the first point is that they're going to have to follow central bank guidance, who has, as regulator, they've said to insurers they have to engage positively with businesses. They have to handle claims effectively, properly, and in a timely fashion, even going so far as to alert policyholders to particular terms and conditions that may be to the policyholder's benefit. They've also said that claim settlement offers must be fair, taking into account all relevant factors and reflecting the best estimate of the level at which the claim should be paid out. In the UK, there's been recommendations made about interim payments where the policy is likely to respond. If there's any doubt about the meaning of a term of an insurance policy, it should be construed in the way in which is most favourable to the policyholder. And media reports have also said that the central bank is closely looking at all of these issues against the backdrop of the Central Bank Consumer Protection Code and the EU unfair terms in consumer contracts regulations. There's also been a lot of political interest and interest from the FSPO, the Financial Service and Pensions Ombudsman. What insurers will then do is review what perils your business interruption cover extends to. And there isn't any one size fits all because there's no singular wording. So it has to be assessed on a case-by-case basis against the specific policy wording. In general terms, though, these clauses are typically framed to reflect losses arising from property damage claims, where the perils are defined in terms of fire or flood. Those covers will only sometimes be broadened by extensions to other interruptions caused by perils such as denial of access or notifiable disease. And you then get two relatively clear-cut situations where, on the one hand, which might be the minority of cases, if a policy covers business interruption caused by notifiable disease or what's called a non-damage denial of access without qualification or caveat, then the claim should be met by the insurer subject to the applicable limit of indemnity. On the other hand, if the policy doesn't contain cover for losses arising from a notifiable disease or non-damage denial of access, or if it's a case where the policy lists a notifiable disease exclusion to liability, then unfortunately, insurers are unlikely to cover those losses. Indeed, the only way a declinature could probably be successfully challenged in that case would be having an argument accepted that the virus has caused physical damage to properties. And that's a difficult argument at the best of times, but in particular where premises are largely closed at the moment. And this is reflected in the statistics that have been available so far on this issue. The Association of British Insurers has estimated that less than 10% of UK businesses are likely to have a notifiable disease extension in place. And the Financial Conduct Authority in the UK has concluded that most policies may have basic cover but don't cover pandemics, and therefore would have no obligation to pay out for the current crisis. So this means that there will be a lot of policyholders whose policies will not pay out in respect to claims, unfortunately. There are 37,500 estimated Irish businesses that have policies which do mention notifiable diseases. Just to explain, that's one really that a medical practitioner must by law notify to health authorities, and COVID-19 has been so designated since February 2020. Again, though, it's a question of the terms in which the notifiable disease is referenced in the scope of cover, because there can be a wide variety of them. And this is where maybe the media have given out about insurers relying on legalese, technical jargon, or small print. But what I would say is that the policy is a contract between insurer and policyholder. So it's really a case of applying contractual interpretation principles in order to assess whether a claim is accepted or not. In terms of the variance between different policy wordings, some will say that an occurrence or outbreak of COVID-19 must take place on the premises itself, and where premises have already been closed by government direction, this criteria can't be met. And the logic of including it in those terms is really that if you've got a restaurant where there's salmonella and that restaurant has to close for a month, that's why it's worded in that particular way. There are other policy wordings which say there has to be an outbreak of a notifiable disease on site or within a specified geographic radius, be it 24 or 40 miles. And given the nationwide spread of the virus, this is where a lot of the controversy has arisen, particularly because there's been conflicting approaches taken between insurers such as, on the one hand, AXA, who, according to media reports, have up to 4,000 policies that they potentially will be paying out on. On the other hand, FBD, along with other insurers, Aviva and Hiscox, who have said that they're not prepared to do so on the basis of their interpretation of the clause. So we'll just hone in for a moment on what has been reported as the three grounds for FBD's declinature of those claims. Firstly, they say that the closure wasn't caused by outbreaks of disease or within 25 miles of the premises, but by national considerations arising from the general pandemic, such as social distancing. Secondly, that COVID-19 doesn't fall within the scope of the infectious disease clause in terms of what they say were the parties' reasonable contemplation when the policy was entered into. And finally, that the business interruption is properly as a result of social distancing practice and the government restrictions. I think this raises a really fundamental question about whether these clauses were intended to cover a global pandemic or not. And in such polarized positions, it's unlikely to be resolved readily or quickly. And you've already seen globally in litigation unfolding on a class action basis in both the UK and Canada. So I think it's really a case of watch this space on those particular fronts. But there might be some focus on the fact of, well, my premises is closed, so I haven't been able to have an outbreak of COVID-19. How am I impacted? And really the easiest way of that being covered is what's called a non-damage denial of access, which means that financial losses are flowing from where a policyholder cannot secure access to their premises for reasons other than physical damage, namely a government direction, which the central bank has clarified should be acceptable. The problem is that there's not a lot of policy wordings that extend that far. Most of them are limited to what's called damage-based denial of access situations, where access is prevented by reason of damage to another premises, which brings us back to what we spoke about earlier, being, has the virus caused damage to premises policyholders or ones that they rely upon? And I think, again, it's a difficult argument to bring home. If you're in a situation where you have made a claim and an insurer has declined it and you feel aggrieved by that, you do have entitlements under your policy. It might have compulsory dispute resolution provision, or it might be silent on it, in which case there may be some options, be it going to the courts, going to an arbitrator, or the FSPO, the Financial Service and Ombudsman, Pensions Ombudsman. Whichever situation arises, our recommendation would be to seek professional advice, liaise with the broker to understand exactly where you stand, the advantages, disadvantages of each option, and a key issue will probably be the timescales involved as well. You might also pose the question, well, given the unprecedented nature of this event, can regulators or governments force insurers to pay out for business interruption losses? And in short, not by those means. The only way insurers' declinatures can be revised or revisited is where you've brought a successful challenge of the type outlined. A situation where carte blanche business interruption risks will be covered would set somewhat of a dangerous precedent and could really create material insolvency risks that could only ultimately undermine policyholder protection and market stability on a much wider basis. You might then understandably ask the question, well, where are we going with all this? What's going to happen going forward? And this is a particular issue when it comes to renewal, because there's a lot of uncertainty for insurers who had any notifiable disease cover about how to quantify and price a risk such as that unfolding at the moment. So what insurers are tending to do now at the behest of their reinsurers is to exclude any form of notifiable disease cover. And that's really a huge risk if there's going to be a second wave. And it's far from satisfactory for businesses in terms of not being able to get the protection that they need. Some market commentators have advocated as a result that there be some form of public-private partnership, which is effectively akin to what was put in place during World War II for risks that couldn't be insured at that point. I think there's going to be a lot more discussion on this and a lot more debate, but in summary and in conclusion, what I would say is ostensibly a business interruption policy is designed to put a policyholder back in the position they were in before the peril occurred. A word of warning is for those who do have claims that are paying out, there will be a reduced limit of indemnity or duration of cover, so that has to be factored into any assessments. Unfortunately, many companies simply are unlikely to have any entitlement to cover because of the policy wording. As mentioned earlier, liaising with your broker, taking professional advice is essential in these difficult times and in response to these difficult situations, because really there are no easy answers to the question of business interruption, and insurers will have a role to play, but it's going to be a relatively limited one, and one that might be characterized by increasingly acrimonious disputes between insurers relying on their interpretation of policy wordings and aggrieved policyholders who are taking a different stance to that. But I think it's going to be one where there'll be a lot more attention and focus as the weeks and months unfold ahead, and as we find out more about this crisis and how it's going to affect businesses, with government playing a particular role as well. So, look, I hope that's been as helpful as it can be in the current circumstances. happy to take any questions at the end. And what I might do now, just with an eye on the clock, is pass on to my colleague Shane Costello, who's going to talk about employment risks in the current crisis.
Thanks, Michael. Yeah, guys, hi to everyone. Good afternoon. My name is Shane Costello. I'm an employment lawyer with Holmes O'Malley Sexton. I've been with the firm just over 8 years now, and as you can imagine, we've had a very busy few weeks since the COVID crisis hit. So what I'd like to do is just give you a flavour of the issues that we've seen in the marketplace, what we've seen clients do, and what we've been advising clients on how to address these issues. So there's three main options which can be implemented now to reduce cost, and I'd like to look at these options in terms of if it's legally possible to do so, how do I affect such measures, and then what are the risks to doing these. So the best way to talk you through this would be by giving you a hypothetical example based on what we've seen recently in the last few weeks. So we've got a company who has had a very strong 2019. Q1 2020, they made a good start to the year. Obviously, the COVID crisis hits at the very end of Q1. They're looking into Q2. Turnover is immediately down 25% due to the coronavirus. You're looking ahead to Q3 and Q4. An awful lot of unknowns. The turnover could even drop to 50% of where it was, possibly even more. So companies, in order to survive, they look at their turnover, they see it's down, they know that they have to reduce cost. So what I'd like to do is set out some of the options that we've seen employers take in order to reduce their overheads. Obviously, workforce being the largest overhead for many companies. So the first option would be to apply a pay reduction. The key focus for government recently has been to maintain the employer-employee relationship. And we've seen with the COVID welfare schemes that has been the main intention of the schemes, to make sure that there is no breakage of that employment relationship. So really, it's in order to have a swift bounce back of the economy, keep the numbers of employees under the roof. And obviously, in 2019, one of the key risks or topics that employers used to come to us with was the retention of talent. How do we keep staff? They obviously want to now try and keep their best people at the moment, rather than just having to lay off all staff or let them go, and avoid a temporary or permanent breaking of that employment relationship. So legally, can a pay reduction be applied? In short, without the consent of the employee, there is a risk that you'll be in breach of the Payment of Wages Act. So what we'd say is, to mitigate this risk, you should consult with your employees. Now, some employers would say, look, how can I go to someone and ask them for a pay cut? Well, if you lay out the options to your employees on the table and say, look, you either have a pay cut, or there could potentially be some layoff or some redundancies down the line. You know, I think it's one of the sensible decisions to be made by the employee to take the pay reduction. So the second option then, in terms of reducing cost, it has two aspects to it. It's layoff and short time. You would have heard a lot about these two topics in the last couple of weeks. So both are temporary reductions in the number of the workforce. It's a temporary breaking of that employment relationship. And I suppose to give you some better explanation of what both are. So layoff arises where an employer is temporarily unable to provide any work for the employee. So the employee does not report for work, and then the employer will not pay the employee, but only if the contract of employment allows them to not be paid for the period of layoff. Short time then is where there is a reduction in the amount of work down to less than 50% of their typical hours worked in a week, and they're also paid less than 50% of their typical weekly wage. So how do I implement a layoff or a short time? First things first, you have to give reasonable notice to staff. Reasonable notice I suppose in the current climate has come way down. Often you'd expect 3 or 4 days notice, possibly even a week. But in the recent crisis, we've seen that reasonable notice has come down as short as 24 hours. So if there's a dramatic, urgent need to reduce the numbers of staff because of the cost, the overhead, employers have in the last few weeks given just 24 hours notice for a layoff or short time. So one of the next key concerns in terms of implementing layoff and short time is the selection of particular employees. So if you have, for example, 10 general operatives who are working on a factory floor you only need to pick 4 for layoff because that's how much the overhead reduction is required. How do I go about picking those 4 out of the 10? So really, to mitigate the risk there, you should use a selection matrix. So what a selection matrix is the table set out with headings, and the headings are basically something like qualifications, skills, contribution to the rest of the business, and each employee should then be graded under each of the headings. The result then will give you the lower scoring employees, and they're the ones who should be selected for layoff for short time. So then how does this temporary scenario come to an end? So typically after 4 weeks continuous layoff for short time, an employee is entitled to claim a redundancy from their employer. That's also 6 weeks in a 13-week period. So it's 4 continuous weeks or 6 weeks in a 13-week period. Now, in a great move for employers, the recent COVID-19 emergency legislation, which was passed by the Oireachtas at the end of March, actually suspended this right. So employees can no longer claim a redundancy from their employer for this emergency period as is defined in the legislation. So that's currently up to the 31st of May. So currently you can put your staff on a layoff without any risk of them claiming redundancy. Now, it remains to be seen whether that emergency period is extended beyond the 31st of May, but as things stand, it probably looks like it does. This leads us into our third option. So that's the good old-fashioned redundancy. So everyone's probably familiar with the concept of redundancy, but just to give you the definition, so it is a permanent cessation of the role, and the employment relationship comes to an end permanently. So how do you affect the redundancy then? First, I suppose you have to consider how many employees are needed to be made redundant. What is the cost implication of that? What is the saving? These are all key decisions that need to be made in terms of demonstrating the fairness of the procedure. So secondly, then put your employees at risk of redundancy on notice that they could potentially be made redundant. That's again a key step, and it's all about that open communication channel with your employees. Number 3, select the pool of employees who are going to be possibly made redundant. So selecting the pool means, again, back to our example, you've got 10 general operatives on the factory floor. It's any employees who are potentially do similar work or comparable employees should be put together in a pool, and it's of them should be people who are selected for redundancy. So again, applying the selection criteria is by way of selection matrix. Set out your headings, grade the employees, come up with your results, and those persons are the persons selected for redundancy then. A key theme throughout the whole selection and redundancy process should be for employers to act reasonably. So that is done by way of acting by way of fair procedures. It's important to consult every step with employees, get their opinion, open up the communication channels, and have a paper trail through each decision you've made, whether that be at board level, at management level, minutes of meetings, all key steps in terms of any kind of defense of a claim that may come down the line. So what are the risks in terms of affecting a redundancy? Well, an employee could claim that it wasn't a genuine redundancy. They could claim that they were unfairly selected for redundancy. They could claim that it wasn't impersonal, which means that they were selected because of who they are rather than their role. So that's the key step in the selection matrix, that you can point back to that and say, no, this was done on an impersonal basis. The test was applied across the board to everyone in the same manner. So what can it lead to? It could lead to an unfair dismissals claim in the WRC, the Workplace Relations Commission, if someone has a year of service, or it could lead to a claim for wrongful dismissal in the High Court if someone has less than a year of service. They're quite rare. I suppose finally, one point I'd like to touch on is a kind of a logistical point, and that is the terms of managing annual leave for employees when they return to the workplace when I suppose the suspension of employment is over. I suppose the key test here is how do you manage when in Q3 or Q4 you have 100 staff, they all come back, they're all got annual leave. How do you have and then take that in a fashion that's not, I suppose, all taking it together? You can compel an employee to take annual leave. Now, I suppose it has to be, subject to you reconciling that with the work requirements, family responsibilities, and also the employee's right to take rest and recreation. Now, a key point here is that there should be at least 1 month in terms of notification and consultation with the employee representative or a trade union if you have one in place before you compel an employee to take annual leave. So that's it from an employment law point of view. Again, as Michael said, happy to take any questions at the end. And also, our contact details are available on our website. I just hand you over to Coach Love, who will have a quick chat now to you about force majeure clauses.
Hi everyone, my name is Coachley Love. I'm a solicitor in our commercial litigation unit. So I deal with contentious matters, disputes which commonly arise under contract law, so under commercial and construction contracts largely. So what I'm going to look at today is the topic of force majeure in commercial and construction contracts. So like the other topics we're looking at today, it's very topical with the coronavirus pandemic. So what we've seen over the last month is the government putting a bar on all non-essential work, which is having a profound effect obviously on both commercial and construction contracts. So in terms of non-essential work then, what this means in the construction sector is really any work or essential health related work dealing with the coronavirus crisis. It also bars anything that's not repair and construction of critical road and utility infrastructure, or delivery of emergency services to businesses and homes. So anything else really in the construction sector has been barred for the time being. So as I said, this is having a profound impact on contracts and mostly contractors who ordinarily would be subject to LDs and penalties for non-performance of their contractual obligations, and also for delay to the contract. So contractors are finding themselves unable to meet deadlines and to perform the obligations that they have under the contract. So we're seeing a surge in requests for legal advice from contractors over the last number of weeks who are coming to us really looking to find out what they can do to prevent these claims and to mitigate LDs and penalties at the end of the contract for being unable to meet deadlines and for being unable to comply with their contractual obligations really. Now one clause under a lot of these common contracts that we've seen and is becoming increasingly topical is the force majeure clause. So force majeure clauses are standard boilerplate clauses that would arise in most contracts. What force majeure means, for those who doesn't know, it translates as superior force. It means an act of God, and typically it's the type of clause that would cover unlikely events such as warfare or natural disasters. So we've had people coming and looking to see if their force majeure clause can extend to this type of event, so pandemics and diseases. Now really what the answer is that it has to, the force majeure clause is what's known as a creature of contract. So it has to actually arise in the contract. It can't be implied into a contract. So the Irish courts won't put one in there or imply one into a contract if it doesn't actually exist. The next thing is that the wording of the clause itself must provide for pandemic or disease of this nature. So if the force majeure clause is limited to specific events which doesn't include disease or pandemics or anything similar, then the courts will be reluctant to imply one in there from what we've seen before. Now what may arise is that there's a non-exhaustive list of what constitutes a force majeure event, and in those cases there may be scope to argue that pandemic and disease can be covered because it's such an unlikely event outside of both parties' control that it may apply. So the key question then, can it be successfully relied on in relation to COVID? So obviously, as Michael said, this is an event without precedent. There's no precedent there to say yes or no one way or another. So the answer is that potentially it could apply. But it's subject to a number of considerations legally. So the first and foremost then, as I've mentioned, is that it's a creature of contract. It must actually be in the contract itself, and it must either be a non-exhaustive list of force majeure events or else it must be expressly provided for. So secondly then is the causal link. So what a contractor would have to prove is that the coronavirus crisis is what actually led to the delay or the non-performance. You can't look to rely on the coronavirus crisis to justify a delay that would have arisen anyway. It has to actually be caused by the pandemic itself. Another key factor then is mitigation. So contractors should be taking steps to mitigate delays and mitigate the non-performance insofar as possible. What I would say also is to keep records in terms of mitigation, the steps that a contractor has taken to actually prevent the delays and to prevent the non-performance. And finally then is compliance with notification requirements under the contract. So the contract will usually say that where there's a force majeure clause or another type of clause, which I'll look at in a minute, where those clauses operate under the contract, there are certain conditions that need to be complied with in order for them to operate. So notifications to the employer and to the main contractor. If you're a subcontractor, there'll be certain requirements that have to be met. So it's crucial that you look at the contract itself to see what it says and to see what the requirements are. Just to note that previously with force majeure clauses, while they're very uncommon, they're not often relied on, but the courts, and there's precedent in the UK that says that the courts will adopt a very narrow interpretation. So the courts will look at the words themselves rather than trying to imply an interpretation of the parties into the contract. Now that being said, we're in a period of uncharted waters, and it certainly doesn't sit well with me that the courts could punish a contractor for complying with government mandate. But that being said, the terms of the contract will apply and the courts will be reluctant to go beyond the scope. So what we're seeing then is a call from the Construction Industry Federation of Ireland to Europe, to the FEIC in Europe, to actually declare the coronavirus pandemic as a force majeure event within Europe. So if this was to happen, it would obviously assist courts, judges and other arbiters like conciliators and mediators to actually say that this is a force majeure event under the contract and to allow these force majeure clauses to be relied upon. So as matters stand then, it's really uncertain as to whether you can rely on a force majeure clause successfully. I think certainly you have to look at the contract, see what it says. First of all, see if there is a clause in there, see what the requirements are of that clause in terms of notification, and keep your records in terms of mitigation then and to prove a causal link. Now, where a force majeure clause isn't present, there are other potential options for contractors that are in difficulty or other parties who are in difficulty under their contract in complying with the requirements. So one of those then is the doctrine of frustration. So this is a common law doctrine under contract law, that where a contract becomes frustrated, so where the parties can't comply with the requirements of the contract or their obligations, that they can walk away from the contract because it has become frustrated. Now, like force majeure clauses, and even more so, the courts have a very high threshold, I suppose, in applying the doctrine of frustration. Mainly because the consequence of applying that doctrine is that all parties' obligations under the contract are discharged and the contract is essentially no longer in existence. So I'd be reluctant to advise a client to rely on the doctrine of frustration solely, and it's much better to actually have a clause in the contract that you can point to justify delay or non-performance. Another example of a clause then, which may apply here, is change of law clauses. So they're less common than force majeure clauses, but a change of law clause in some contracts will tell the parties what to do where the law changes when the contract is in existence. Now, in terms of law, it would often be limited to legislation, but in some instances it can also include regulatory guidance or government advice. So obviously with the coronavirus crisis, the government mandate is what has caused these delay in non-performance. So change of law clauses may entitle you to an extension of time in some instances, depending on what they say. And lastly then, event clauses. So an example of this is in the public works contracts. So delay event clauses are in there. So there's a schedule which lists various delay events and what constitutes a delay event. So where the particular event that causes the delay or non-performance falls within one of those definitions, and there's one in there that would potentially cover coronavirus. It says that provided various conditions are complied with, that you will be entitled to an extension of time. So to summarise then, it's crucial that any entity or party to a contract which is affected by COVID reviews the contract and the specific wording, and not only the force majeure clause, but also other clauses in there that set out the notification requirements. So is there a force majeure clause? If not, are there any other clauses like the change of law clause or an event clause that might apply here to allow you an extension of time? What are the preconditions for compliance with that clause? And then in terms of mitigation, causal link, just keep your records, and if necessary, seek legal advice. So that's it from me, a whistle-stop tour of the force majeure clause and its potential application, potential other remedies under commercial and construction contracts that can be relied upon, and as with Mike and Shane, I'm happy to take questions at the end. Thank you. To Robert Kennedy.
Quaitlin, so for those of you who don't know me, my name is Robert Kennedy. I am a partner in Holmes O'Malley Sexton, having been with the firm for the past 26 years. I am the head of defence and insurance litigation and contentious business. My brief is to talk to you very briefly about employers' liability in COVID-19 and how that is going to impact on us going forward. So bear in mind, although we are in the middle of a very significant emergency, your duties as employers to your employees continue on as before. So where do these duties come from and what are they? They come from two different places. The first is from government passed legislation, the secondly from judge or court made law of negligence. Dealing with the first aspect, the relevant legislation, there are two pieces here. The first of which is one that you will be very familiar with, and that is the Safety, Health and Welfare at Work Act of 2005. That act imposes a duty on employers to ensure as far as is reasonably practicable that the safety, health and welfare of their employees is safeguarded. Main responsibilities there are as they have always been, a safe workplace, a safe method of work, safe equipment, appropriate supervision and training, protective equipment where appropriate, and the provision and maintenance of facilities and arrangements for the welfare of employees at work. So as you will see, there are particular considerations with regard to the current pandemic that will apply there. Bear in mind, this legislation applies to employees working on site where they've always worked, but also to employees who are working from home now. Breaches can give rise to prosecution, but also give rise to civil actions for damages. We obviously haven't seen any of these as yet. There is a reported action, class action being taken in Austria in relation to COVID-19 infection. Who would have thought that the famously non-litigious Central Europeans would lead the charge over the litigious Irish when it comes to initiating actions for damages. The second piece of legislation is one that has been there for a very long time. It's the Health Act of 1947. This piece of legislation is actually where the Department of Health is getting the legal force behind our current restrictions and regulations. But there is a provision in that, section 43 of that 1947 Act, obviously in place long before the current pandemic, which allows for a person, an employee, to initiate civil proceedings for damages if the employer fails to take actions required pursuant to regulations, which results in the employee being infected with the disease. So again, it's an enabling provision there to allow an employee to sue an employer in circumstances where that employee becomes infected with COVID-19. Again, with the overarching provision that the employer must take reasonable care to ensure that that does not occur. The second area as to where the this will arise is the general negligence provisions that have always been there. That is the court-made law, which says that the employer owes a common law duty of care to their employees under the law of negligence. So let's take a very, I suppose, simple example here. Say if employees are working in a manufacturing plant, the employer has a look at what needs to be done and provides extra hand washing and sanitizing facilities for the employees, but does not allow for relevant and proper social distancing, say, between workspaces or whatever, and suddenly there is an outbreak of COVID-19. The court would obviously consider, in the event that proceedings were brought in those circumstances, as to whether that employer had discharged their duty of care to the employees, and what they did, was it reasonable, and was it something that a prudent employer would have done in all the circumstances. There's obviously no simple answer to doing what is enough, but it will all come down to individual circumstances in each case. To quote the great Winston Churchill, he said many years ago, again, however beautiful the strategy, you should occasionally look at the results. And that is precisely what the courts will do, employing the 2020 vision in looking back at what occurred, to see as to whether what the employer did was reasonable or otherwise. There'll be very potentially serious consequences from a COVID-19 infection if the ultimate occurs and that employee, in fact, died as a result of an infection. Then that could give rise to a very serious claim for wrongful death, which would be a suit that could run to many hundreds of thousands of euros. So as a prudent employer, what can you do? Obviously, at the moment, non-essential workers have been directed by the government to stay at home. Companies in both essential and non-essential sectors have now made that transition, in part or completely, to having their employees working from home, and that remains the position for the moment, to be reviewed next week. If your employees cannot work from home and they still must come to work, then there are some measures that you can adopt in order to ensure their safety. They are very fundamental issues, like displaying the HSE posters and promoting good hand and respiratory hygiene. Redesign your workstations to ensure social distancing is maintained. Review existing risk assessments in light of the new working practices. Provide training based on any new procedures implemented, and supervise your employees to ensure that that training is being followed. So you should follow the guidelines as they have been set out, train your staff, document that training, and ensure that the training is being followed. Everything that you would normally do as a prudent employer, but with a particular focus when it comes to COVID-19. As a last thought, please remember, nowadays, in the very strange world that we find ourselves living in, bedrooms and patio tables and kitchen worktops have now all become a somewhat unconventional workplace for many employees. The employer's duties are now actually extending into people's homes in a way that would never have occurred previously. So as an employer, it's important that you're aware of this, that you ensure that your employees who you do not have direct control over when they're working from home are taking appropriate breaks and have been provided with the necessary equipment to enable them to do their jobs from home. So bear that in mind. That is going to be undoubtedly a source of contention and litigation into the future. So I hope this has been useful for you. I'll now pass you over to my partner, Sandra Egan, and she will talk to you about landlord and tenant issues that have arisen in the current crisis. Thank you.
Thank you, Robert. Afternoon, everyone. As Robert mentioned, I'm a partner in the Commercial Property Department in Holmes O'Malley Sexton, and I'm going to just, as a wrap up, touch on some issues that we have come across the desks in recent weeks, both on the part of commercial landlords and tenants. So many commercial tenants will understandably be wondering what their options are pursuant to the commercial leases if they're unable to pay their rent. This is almost a certainty for most commercial tenants at this stage due to the closure of all but essential businesses. Likewise, landlords are wondering what their obligations are vis-a-vis commercial tenants that approach them for some sort of abatement or accommodation to be made. It really is imperative that commercial landlords confront the reality that we're currently facing, which is that many commercial tenants will be unable to pay their rent over coming months due to the almost complete cessation of their business function. I will touch on some of the traditional remedies that landlords would have in a few moments, but I suppose the key point to mention at this stage is that most commercial leases do not have an automatic rent suspension clause on the occurrence of a force majeure event. So certainly our experience to date is that really engagement and forbearance have been the approach that have been taken by most landlords and tenants. Now that's not to say all, but in terms of engagement, some of the options that parties have been looking at have been, for instance, a commercial rent deferment. So, for instance, the rent for Q2 and Q3 for 2020 would be spread out over the duration of the lease. Now, if the lease is of a longer duration, that might not be as practical. Likewise, a second option people are looking at is if there's a deferment of the rent for perhaps a 3-month period, that 3-month period is then being added on to the end of the lease. Again, more practical with a shorter term lease. Landlords are also looking to charge interest if there's a deferment to ensure they're in no worse a position. And parties are also taking this opportunity to, in some cases, renegotiate the terms, certain terms of their leases. So, for instance, if you have a lease with perhaps 12 or 15 years left to run, but the tenant does have a break option, which is coming up in 2 years' time, for instance, a landlord may consider it worthwhile to agree to some sort of deferment of rent in return for negotiating out that break clause. And by the same token, most tenants should be reviewing their leases to see if there are any break options that they could consider exercising in the short term to give them more options during the course of discussions with landlords. Another clause that parties are looking at are the rent review provisions. So in circumstances certainly where there's open market rent reviews, which would allow for an upwards and downwards rent review to take place at the next rent review, in light of the fact that in all reality rents are likely to go down, landlords again are looking favourably on some sort of abatement in return for fixing the rent for a period. The final option the parties are looking at, but it's not something that's open to a lot of landlords, is essentially a rent forgiveness, so a rent-free period. Now, obviously, landlords who themselves have a lender or a charge holder or bank in the background, that may not be practical. So for those landlords, again, it's key that they engage with the lender, their own financial institution, because clearly a landlord's not going to be able to reach any agreement with a tenant unless they themselves reach agreement with their financial institution, because clearly in most cases the rent is servicing their loan with their financial institution. From the lender's perspective, there's also little merit in a lender at the moment taking any action against a landlord, because in all reality they're not going to be in any better position than a landlord, for instance, in evicting a tenant or getting a new tenant in place in the short term, and if they do, it's most likely to be at a lower rent. I suppose the final couple of comments, if you are agreeing some sort of abatement or some sort of negotiation or variation to the terms of your lease, would be to really look for financial data to back that up. So clearly evidence from a tenant that they have in fact suffered a loss, reduction in their turnover, reduction in their business to support the position that they're currently putting forward. And secondly, we would strongly recommend that if there is a variation or an amendment to the terms of the lease, that this is reduced to writing in a deed of variation or some sort of side letter, really to ensure that its enforceability and to avoid a dispute at a later stage. because certainly these things will be looked at again. Just to touch on some of the other options that landlords have at law, obviously they can sue for non-payment of rent, they can petition to wind up a tenant, but really forfeiture is the one that comes to mind in the event of a dispute between landlords and tenants. So generally the forfeiture events are non-payment of rent, breach of a covenant such as a keep open covenant, which obviously would apply in more of a retail or shopping centre scenario, or a tenant insolvency event. I suppose a degree of caution would be recommended, certainly for any landlords at the moment that are considering serving a forfeiture notice or taking any other steps to effect forfeiture. First of all, as I mentioned, just from a practical perspective, how likely is that landlord how likely is it that that landlord will get another tenant in the short term? And if they are successful in doing that, it is most likely to be at a lower rent. Secondly, and the key point is, forfeiture is an equitable remedy. So there is a degree of judicial discretion. So in circumstances where a tenant is unable to pay rent, unable to stay open, and these are for circumstances and for reasons that are entirely outside of their control, such as a global health crisis, it is likely that court would find in favour of such a tenant. And the final point I suppose to make on forfeiture is something that has come up recently in an injunction in the High Court, is under the Emergency Measures and Public Interest Act, COVID-19 Act 2020. Now, from a tenancy perspective, really this was to introduce measures to ensure that termination notices and rent increases were not served during the emergency period in residential tenancies. The emergency period is defined for 3 months from 27th March 2020. But in the course of Dáil debates, a new subsection was added which provided that all proposed evictions in all tenancies in the state, including those not covered by the Act, are prohibited. Now, it doesn't appear from the commentary that it was ever really intended to capture general commercial tenancies, but it seems to have had that unintended consequence, and that is a fact that a commercial tenant in a Dublin property relied on in the High Court last week to secure an interim injunction against a landlord that they claimed were preventing them accessing their property. So, as I said, while not all landlords are taking the same approach, it really, from our perspective, forbearance and engagement are the order of the day, and that is certainly what's coming across our desk. And I think in all reality, a common sense, practical approach to issues that are arising is going to assist in helping viable businesses getting back to functioning insofar as is possible to their previous levels once the restrictions are lifted. So that's it for me on the commercial landlord and tenant side. I will take this opportunity to have a look at what questions have come in, and we're obviously happy to take. We're keen to keep it to an hour, so we'll try to wrap up by 1:30. But I'll have a look at what questions have come in and get the other panelists to join in dealing with them. The first one, Robert Kennedy, I'll direct with you if that's okay. I'm not able to carry out a risk assessment for employees who are working from home due to the restrictions. How do I comply with the health and safety legislation?
Thanks, Sandra. That when you hear the words, I'll direct that question to you. It's hard to sync, but this is something that I can deal with. This is a very good question, and I'm not surprised at all that it has been asked, because it is a real worry for employers. Is this a situation that's going through your mind, that when your employees are working from home, that you have to go out and knock on their door? Not that you're allowed to do so within the current lockdown provisions, but you couldn't do so anyway, and go in and inspect that home as being a place of work. You're not expected to do that. There's an overarching duty on an employer to act reasonably, but not to act exhaustively. There's also a duty on employees to ensure that their workspace is safe and proper. But to answer this question, you would be doing what you can do. You would be dealing with it by way of online training. You would be explaining to your employees that this is now a place of work and to ensure that it is safe, that their chair is comfortable. You would be pushing the duty back onto the employees. You would be suggesting them that they get up and move around and take proper breaks and conduct their business as if they would do if they were actually at work. So be reasonable about it. But for instance, if you got a complaint from an employee to say such and such is wrong, my chair is broken or something like that, you would have to go and do something about that and find a solution. So communicate with your employees and be reasonable, and that should see you through this.
Thanks, Robert. Michael Murphy, if that's okay, I'll direct this to you. I've not been able to visit my business premises in weeks as it is a non-essential service. Do I need to notify my insurer in these circumstances?
Yeah, so look, I imagine there's a lot of business owners that are in this very situation, and it may not be top of their agenda to contact their broker or their insurer. And there's two ways looking at it. The first is to say, strictly within the parameters of the policy, there typically would be a clause to say that if a premises is going to be vacant for a sustained period of time, it would be appropriate that the insurer would be put on notice of that, because in ordinary circumstances, that means it's at an increased risk, be it of fire, theft, or other perils occurring. In a commercial sense, a lot of insurers have taken more of a pragmatic view because of the extent of government closures, and the regulators have encouraged them to take a more pragmatic approach to this issue. I think good practice would still be to be in touch with your broker if you're talking about business interruption issues, if you're talking about, you know, in some cases it might be dealing with refunds in relation to motor vehicles because there's less cars on the road, or other such issues. So as part of that, I think it's no harm to put your broker on notice so that the insurer can be told to comply with the formal requirements. And, you know, I think you just tick the box then, as would be appropriate under the policy.
Thanks, Michael. The next one I can deal with. So I rent space within a building. The landlord has closed the business or building completely, and I cannot get access to my workspace. Do I need to pay rent for that period? A couple of comments arise on that. I suppose under commercial leases, one of the landlord's main covenants, and often their only covenant, is to allow quiet enjoyment and provide quiet enjoyment of a workplace to the property, the subject of the lease. Where that is interfered with, potentially the doctrine or an argument for frustration could apply, which is a similar point Kochla made. Now, the bar generally for successfully arguing frustration is generally quite high. I think, though, in the current circumstances, again, it would really be back, and I would really recommending engagement with your landlord in those circumstances to come to a mutually satisfactory solution. But I think certainly interference with the quiet enjoyment would be a good argument for non-payment rent in those circumstances. Just touch on the next question for you, Shane, if that's okay. What do we do about employees on layoff for short time who will return to work with full entitlement of annual leave and bank holidays? This will have a significant impact on my business operations just when we're trying to rebuild and get back on track.
Okay, thanks, Andrew. Well, I suppose it touches on two different points that I raised in the chat, in the talk. So if someone is on layoff, it's a temporary breaking of the employment relationship. They actually don't accrue annual leave during that period. So they're entitled to their bank holidays by way of legislation, but they don't accrue annual leave while you're on layoff, right? But with short time, because it's a pro rata reduction of your hours worked, you get a pro rata reduction of your annual leave accordingly. So just to kind of close the circle on that, when they do come back in quarter 3, quarter 4, you would have asked them hopefully to have taken some of their annual leave. So for example, maybe by the end of June 2020, if you give them some notice now, you could say to them, look, we'd like you to have taken 10, 11 days annual leave in total over the course of 2020 by that period, so that when you come back, it's effectively just half the year to go after annual leave entitlement left.
Yeah, okay. And I think we just have time for one last question. Kochlan, you've mentioned public contracts, but do standard private contracts usually contain a force majeure clause?
Thanks, Sandra. Well, standard private contracts, there's two types. So obviously there can be private negotiated contracts between the parties, and that will depend on what those clauses actually say. Now, if a standard precedent has been used either from the FIDEC terms, JCT clauses, NEC, then I'm familiar with some of those clauses that do in fact cover it in some situations. So the FIDEC yellow book clauses, I think what it provides for is exceptional events. So similar to the delay event that I mentioned in the public works contract, exceptional events provide for things similar to events like this. Now, it doesn't expressly provide for disease or pandemic, so it remains to be seen whether those type of contracts will be determined to allow for this type of event. I know they provide for strike and lockouts. You could arguably say that you're locked out of your premises as a result of the government mandate where those clauses apply. I think the JCT clauses were another one I looked at recently, and from what I can remember, they have what's known as a relevant event clause. So a relevant event includes force majeure, and it also includes change of law as well, which I would have mentioned during my topic. So it really just depends on the type of clauses that you've agreed to, or if you've privately negotiated your own contract, it'll depend on whether you've included something in there similar to those events type clauses or a specific force majeure clause.
Great, thanks, Catherine.
Sandra, just before you wrap up, there's one comment I see there that is just by way of clarity, and what Mike was talking about. I just discovered from somebody who would absolutely know that there is a commitment by insurers to the Central Bank of Ireland not to reduce cover for vacant properties during the current pandemic. So I'm sure that people will be very, very happy to hear of that fantastic commitment by insurers that has been given. Thanks.
Excellent. Thanks, Robert, for that update. Our website will have links to more information on the topics that we have covered, and I think we will welcome any more comments, and they can be fed back to us through the Chamber. And I'd just like to take the opportunity to thank my fellow panelists and also the Chamber for hosting us here this afternoon, and I hope it was useful and informative to you. Thank you.
Thank you. Keep well.
Stay safe. Thanks, guys.
Thanks very much.
Thank you.